So let's talk about whether you can represent yourself in the Magistrates Court. I'm going to add this video to the website, and if you do have any questions at any point about anything on the video or anything that you've read on the website, then make sure you get in touch. We do always offer free initial advice over the phone. You'll find the contact details on the website. So getting stuck into it then, first thing that I can say is that you can represent yourself in the Magistrates Court. You don't have to take legal advice, you don't have to have legal representation, and you are entitled to represent yourself, to stand up and do the same job as a solicitor or a barrister in the Magistrates Court. But the real question is whether you should, whether it's worth taking that chance, whether it's worth taking that risk. Now, if you've got the confidence, if you've got the knowledge and the experience, then give it a go, give it a shot, see what happens. For those that might not have the knowledge or might not have the experience or even the confidence, then it may make more sense to rely on a solicitor. If you rely on a legal professional, somebody who is more experienced, then the outcome may be different. The chances are they're probably better at it than you. You can do it yourself, but you probably shouldn't. Now, it depends, of course, what offence you've been charged with. It depends what's at risk and what the consequence is. We're talking here about motoring offences. If you're charged with other offences, if it's a more serious offence, where you could be looking at the risk of immediate custody, if it's a Crown Court case, then always make sure that you take legal advice anyway, because representing yourself may not be a good idea in those circumstances. The first thing that I've mentioned are options. Now, whenever you're caught up in a criminal case, if you've been charged with a criminal offence, of course there are options that might be open to you. The two obvious options are that you plead guilty or not guilty. Even if you think you're guilty of an offence, you may not be. There may be various reasons why you're not guilty of a crime that you think you might have committed. It might be procedural issues, technicalities, evidential concerns, legal arguments that you might not think about if you're not taking the advice from a solicitor and you don't understand your options. So one reason for not representing yourself is options. Always try and get a solicitor to advise you, speak to a solicitor, speak about your options, but also options can change throughout the process. Options today may be different to the options available to you on the day of a court hearing. And if you've not got a solicitor with you on that court day, you may not properly understand what those options are and which option is best for your circumstances. The second reason are defences. You may have a defence to the allegation in the same way that you've got options that are open to you. A solicitor is probably the best person to point out what defence arguments apply and why. You might think that you can raise a particular defence when in fact you can't. I speak with a lot of people who think, for example, exceptional hardship applies in drink driving cases. That I can go to court, tell the magistrates that I need my licence for work or that I need to drive my children to and from school, and they're not then going to ban me for drink driving. It might be something that you've read online from 10 years ago. Well, that can't happen in a drink driving case. The offence carries a mandatory driving disqualification if you're convicted. So it's important that you understand your defences, what defences apply and what defences don't apply. And of course, a solicitor is probably best able to set out those defences and explain that to you. Now, third of all, mitigation. Now, if you plead guilty to a criminal offence, you're usually always given the option of presenting mitigation to the court. And the purpose of mitigation is to try and minimise the penalty as far as possible. And so if you're charged with speeding, for example, you might want to tell the magistrates why your licence is important in an attempt to reduce the period of disqualification or to reduce the number of penalty points that the court would impose. And they will take into account mitigation. And mitigation isn't just a sob story, there's a strategy behind the mitigation. It might be character references that you want to present, it might be a personal statement that you want to put forward, it might be other factors or circumstances that are important the magistrates might need to know about. But there's also a lot of irrelevant facts as well that you don't need to tell the magistrates. And there's also some pretty important do's and don'ts with mitigation as well. A solicitor is obviously in the best position to present that mitigation on your behalf, and sometimes it sounds better coming from a third party as opposed to that mitigation coming directly from you. So mitigation may apply in your circumstances if you've been convicted of an offence or are wanting to plead guilty, always try and have a solicitor there to do that for you. A third reason is pressure. Now, if at any point we challenge an allegation, one way of avoiding a conviction is to try and put some pressure on the prosecution, is to raise various defence arguments that might apply, is to ask for the right kind of evidence, is to communicate with the prosecution regularly and then point out to the court when the prosecution slip up, when they don't comply with court directions, when they don't respond to that correspondence, and then to make the appropriate applications in court or outside of court to try and get evidence excluded or cases dismissed, depending on the circumstances of the offence. Of course, that's very, very difficult if you're not represented. Representation doesn't just mean representation in court. Representation is what happens day to day. Is that solicitor dealing with that case day to day, dealing with prosecution material, answering phone calls from the police and the prosecution, setting the case up in such a way as safeguarding your position and giving you the best chance of achieving the best outcome. Trying to do that on your own, particularly if you're also working at the same time, is very, very difficult. And finally, the groundwork. Whenever you attend a court hearing, particularly if it's a first court hearing, it's not as simple as just pleading not guilty. I'm often asked whether I can represent myself in the Magistrates Court for a first court date because it's just a plea hearing, isn't it? All I have to do is go to court and enter a guilty plea. Well, that's part of what's involved for a first court date, but there's a lot more to it than just pleading not guilty. For example, when I attend court and I represent clients, all they have to do is plead not guilty, but I do most of the talking. If, for example, you plead guilty to drink driving, drug driving, failing to provide, careless, dangerous, some speeding offences, mobile phone offences, most offences that go to first court hearings, and you plead not guilty, they won't just list the case for a trial in 3 to 6 months' time. They'll expect to know why you're challenging the allegation. What are the legal arguments? What are the defences? What witnesses are required to attend the trial in 3 months' time? What parts of the prosecution's case can be agreed? What parts can't be agreed and why? What further evidence might you want the prosecution to serve and why? What court directions do you want the court to set? So there's a lot of different discussions that will take place on that court day. You have to be in a position to be able to handle that and answer those questions. Now, of course, if you don't get the foundations in place, it's going to make your job much more difficult then, trying to go on and defend that allegation, trying to avoid that conviction. A solicitor is obviously the best person to be able to build the foundations, the groundwork of the offence, of the case, and then give you the best chance of avoiding the conviction then in due course. If you do have any questions about representation or you're concerned about the cost, then get in touch with me. I'm always happy to explain in straightforward terms what's like to happen in your case, what you can expect, defence arguments that might apply. We don't charge for our initial advice, and I'm able to talk you through our cost structure as well. I will say that it is a fixed fee basis. We don't charge scary hourly rates. It's a fixed fee that we have for the work that we do. So if you're in a position where you're facing the prospect of court and there are criminal offences that you've been charged with, then get in touch with me. You'll find all the contact details online. Always happy to speak and discuss the case with you.